Hello, everyone. It's a pretty big room, so what we want to do is we're going to introduce ourselves a little bit less, I guess, less of an introduction than was given just now, more modest, if you will. But if you don't hear us, please let us know. And we also want to reserve some time at the end for questions. Between Dana and I, you probably have over 50 years of litigation experience. Sorry, Dana. So we have, if you will, been around the block, federal court, state court, arbitrations, locally, nationally, so we can answer a lot of questions you may have. With that said, let me tell you a little bit about myself. The introduction was, thank you very much, was very nice, but what I generally do, what I always do, is litigation. I tell people the best way to tell you what I do is tell you what I don't do. I don't do personal injury, I don't do patent litigation, and we really don't do matrimonial litigation. Everything else is in my, if you will, in my sweet spot, from employment to securities to trust and estates litigation, real estate litigation, and it's really the gamut of business and commercial litigation. I've been practicing for close to 30 years. Looking at everyone here, probably more than, I probably got out of law school before you were born, a lot of you. So we do have a vast amount of experience in any type of litigation, and I will, for one, still love it. So that's the good thing. Dana?
Okay. Hi, I'm Dana Post, and I have been practicing law not so long as Richard, but more than 12 years. I'm currently a senior associate at Freshfields, Brookhouse, and Derringer in New York, where I focus mainly on disputes involving complex financial products, but I also do general litigation. So there's contractual disputes, business torts, and I actually thought that was very clever to say what you don't do, which I don't do the same things as you. So if you're looking for a lesson in personal injury law, we will not provide it today. But anyway, we're both very excited to be here today to walk you through the litigation process and give you some advice and tips. And you're also lucky because Richard and I were adversaries in a case that recently concluded, so we'll be more forthcoming about our advice we could give you and our tactics.
So we're going to start off, we're going to, as Dana said, walk you through the entire process. And obviously it begins with a phone call or a meeting with a client. And I do a lot of plaintiff and defense work. Dana is more concentrated on defense work. So the client comes more to me than to Dana, I would say. And the biggest question you have is, do you take the case? It's probably one of the two toughest questions you have to answer, the second of which is, how much am I going to charge? But the first question of, do you take the case, is a tough one, because I would say, especially in the employment area, 19 out of 20 phone calls that I get, I say, they want to have a meeting. I say, sorry, but it's not worthy. This morning alone, I got a phone call from a guy who was fired by the Garden City Hotel, and he and his wife want to come meet with me. 65 people were fired. I said to them, well, first tell me what it's about, and they're upset that they got laid off. It was essentially a reduction in workforce. So I said, it's not worth the meeting. And deciding whether you have to do a lot of evaluation before you get into the case, especially if you take something on a contingency, because you don't want to find yourself 2, 3, 4 years down the road working like a dog and finding out that there's some big hole you didn't know about, or it's a potential losing case. So what I do is I will sit down with the client. The first and foremost, I look at two things. One is the credibility of the client, because at the end of the day, you have to say to yourself, this person who's sitting in my office at this time or on the phone, preferably in the office, is going to have to be sitting in front of a jury of his or her peers, and do you believe her? Or are there some holes in the story? So that's part one of the process. And part two is, what's the evidence? What are the documents? What are the emails? Are there agreements? What are the torts? And so you really have to go through an exhaustive preliminary review when you do get a case. If you decide to take it, then obviously you can begin one of three ways with a letter, just saying, I represent Susan Smith, who has a claim against you for sexual harassment, or ABC Company, whose securities were fraudulently taken. And the letter is one effective way. The other way, if you want to get more aggressive, is actually draft a complaint. Many a times, I will draft a complaint and say, we've enclosed the following complaint. If you do not want to settle, we'll sue you. And it happens frequently that they will settle. It happens frequently they won't settle. A year ago, I had a case against the Standard Hotel, which was public because I ended up filing it. I wrote them a letter with a complaint. They didn't respond. We ended up suing the Standard Hotel, and it ended up getting some good press because it was a discrimination case. The moment I filed the complaint, we settled. So you just don't know. The third possibility is just to sue. You can either write a letter, you can draft a complaint and give them a draft, or you can just sue. And you have to sort of go through a process to decide which is the best way to do in your particular case. You also have to manage your client's expectations. Dana and I both, spend a lot of time telling our client, what clients always want. I have emotional distress. I have this, that, and the other. And many times you have to say, wait a minute, this is a commercial dispute. That's out the window, and you have to sort of walk your client down where they would be if they win. Because as you take them on to fight the fight, I tell clients I have one fist clenched to fight the fight, and the other hand is open to try to settle. So you have to manage your client's expectation to get them in the settlement posture. My philosophy on litigation is not like everyone else's. I sort of look at my cases as my inventory. I sort of have a businessman's mind, and the quicker I get rid of my inventory, the quicker I sell my cups, the more cups I order. So what I try to do is the quicker I get rid of my cases, presumably the same client will say, wow, great job, you got rid of it. I want to give you more. So I look at cases as inventory, and I try to, if you will, keep the flow going. So it's very important at the beginning to manage your client's expectations, plaintiff or defense side.
Right. And it's, as Richard said, most clients on the defense side as well think they have a great case. And they might, but you always have to look through the documents, and as Richard was saying, I just actually filed a complaint. I don't usually do that. And, I was talking to the business people, and like, we have this great case, and, I said, let me see the documents, and, they slowly came in, and there's weaknesses in every case, and you should be aware of those weaknesses before you go forward or before you respond to a complaint. So usually I am on the defense side, so when I get the complaint, but I think we should, before we talk about that, just talk about litigation holds, because that is a big area that everyone should be aware of, and there's a lot of case law on preserving documents, especially in this age of electronic data. So the standard is basically when litigation is reasonably anticipated, that your preservation duty kicks in. So as soon as that happens, and it's unclear, it's not defined in the rules, it's all case law, and it's all over the place as far as when that duty kicks in. For a plaintiff, it's easy. I mean, basically when the client comes to you and says, I want to sue, or you start doing your fact case investigation to sue, you issue a litigation hold, which means you tell all potential custodians with potentially relevant documents, don't discard any documents. Litigation's anticipated, and you describe what a document is, what potentially relevant documents are. And then on the defense side, it's a little more difficult as to when you should issue that litigation hold. And I'm consulted about this all the time. If there's just a letter writing back and forth, and you're talking about settling a claim, or you don't anticipate litigation, or you think that you'll get some sort of resolution, do you issue a litigation hold? So it is a fact-intensive question, but it's very, very important that you be aware of that, because you could have the best case, and it happens, if you'll read the cases, where if someone doesn't issue a litigation hold, they'll be sanctioned, and adverse inferences will be drawn against them, so it's just a silly way to lose a case. So anyway, so I get the complaint. What do I do? You have two options. You could either answer, or you could move. And move means you could file a motion against that complaint. And the types of motions that you could file are all in federal rules under Rule 12b. I'm sure you learned this in law school, like failure to serve properly, lack of jurisdiction. Most often, though, it's failure to state a claim. And that's the same. It's the New York rule is 3211. So you could evaluate whether you have any grounds to do that. And like lack of jurisdiction, some of those you should realize are waived, that if you don't raise them initially, that you can never raise them again, lack of service of process, which, that won't end the case. Usually the other side will be given an opportunity to serve properly, but if you want to delay, it's a delaying tactic, and sometimes maybe they'll say it's not worth it to serve properly, but that could be waived. Personal jurisdiction is waived. Subject matter jurisdiction is never waived. You could raise that at any time, but you should just be aware of all the different grounds that you can move to dismiss under 12b. Or you could answer the complaint, which you look at the federal rules and the state rules, see how you've been served. And that depends on how long you would have to answer. If they're served by mail under New York State, you get an extra 5 days, but just be aware of that, the exact time that you have to respond. And as far as the answer goes, it's a very simple document. Deny, for me, deny, deny, deny. I mean, you have to admit certain things, but you want to say as little as possible in your answer, because that's basically an admission. So for me, it's a very simple document, but you don't want to deny something that later will come back to bite you, and they'll say, you know what, at trial, you denied this, and what was the basis for denying this? So we obviously have to have a basis, or you could say, deny because you don't have sufficient information to admit or deny at that point. And that's another way to answer it. But my advice in that regard is to say as little as possible.
Yeah, the only exception to that is, you know, when you practice in different forums, we do, at least I do a lot of arbitrations as well.
Right.
And when it comes to arbitration, there's some just sort of different practical rules that I follow. Number one is with a complaint, a statement of claim in that instance, or a demand for arbitration. There's two philosophies. Either I will put in a very general one and then ambush the respondent, because there's never depositions, or I'll put in a very specific one to both let the respondent know and let the panel know. And when it comes time to an answer, if I have a very specific statement of claim and I want to answer it, I may very well sort of rebut some of the allegations. Even though I'm denying, I may want to put a preliminary statement in, something so the panel, when they read it, get a flavor for where this is going. You know, when I do arbitrations, I literally, you know, the arbitrators are generally, the earliest they're in their 50s, many times they're in their 60s, 70s, 80s. So I will tell the arbitrator what I want to do, I will do it, and then I tell them what I just did. Because you have to sort of repeat yourself. So it's not a bad idea in a pleading, a statement of claim or an answer in arbitration, to put, unless you do want to ambush, and I've done that many a times, not give a lot of facts because there aren't any depositions. But those are all sort of tactical decisions you make. But I do want arbitrators many times to, as an answer, to get a little more flavor for what's going on, and not walk into the hearing and really know nothing about the case.
Right, and it's also different in arbitration because there's not an opportunity to move to dismiss. So I view the answer in arbitration as a way to really tell the arbitrator your story, because that's going to be probably one of the only documents he'll see telling your story before the hearing. So you want to give him an idea of what the case is about. And it's really, for arbitration, I view it as telling my side of the story and your theory of the case. So it's a speaking document. And for arbitration, when we say arbitration, obviously we're not focusing on that, but we should just make you aware that before you decide to file suit, you should look at whatever contract or agreement between the party governs to see if there's an arbitration clause, because that is going to require you to arbitrate that dispute. And arbitration could be before the American Arbitration Association, FINRA, there's a FINRA member involved, or if it's a broker-dealer dispute, JAMS, which is a private mediation service. It's the only ones I've been, yeah.
There's also an Amex for securities disputes, but essentially those are the forums. And you have to decide before you even draft the complaint, where am I going? If I have a sexual harassment lawsuit involving a broker-dealer, am I going for arbitration? Because if my client signed what's called a U4, which obligates them to arbitration, or am I going before the federal court? Because there's federal employment laws that are an issue. So you have to sort of decide, and depending on what I think of the case and how it will go, that will many times be, I will choose my form if I can. For example, in a case in which, as Dana said, you can't really make a motion to dismiss an arbitration. They're really not favored. Many forms don't even allow you to do it. So that means the plaintiff can stack that statement of claim with all kinds of things, and it's just not going to be dismissed. If you're bringing that to federal court, you got to be a little more cautious because it will be dismissed, or it's susceptible to dismissal. So once you decide your form, you can decide what to do with your pleadings, whether you want them more elaborate or whether you want them simple.
Right, and the other interesting thing about arbitration is the arbitrator sometimes is not even a lawyer, and also arbitrators don't have to follow the law. So, you know, for a plaintiff, if you really don't think the law is on your side, it might be a way, like if you have, you know, an old lady who lost money, but, you know, she really doesn't have a strong case, the arbitrator might have this, you know, have the sympathy vote from the arbitrator. So, and it works a lot. So.
And you never know. You're literally rolling the dice. I had one in Syracuse a month ago with 3 non-lawyers, which went phenomenally well. They were actually very smart businessmen in their 70s. And I had one in Los Angeles about 3 years ago with 3 non-lawyers, which was abysmal. Abysmal because my client got his, you know what, kicked, but also because it was just very frustrating because you try to, there's some semblance of evidence in an arbitration. We'll get to the hearing later. And many times, if they're not lawyers, you want to try to You have to educate them as to why this is rank hearsay, triple hearsay, or why there's no foundation, but they let pretty much everything in an arbitration. So it's a totally different hearing process. We'll get to that.
Yeah. So I guess we could just talk a little bit about, just again, with filing the complaint, do you want to go to federal, assuming you don't have an arbitration clause, do you want to go to state or federal court? I think you learned this in law school. New York is a court of general jurisdiction. So basically, you could bring a court, besides specific statutory limitations, such as if it arises from a family law, like a matrimonial dispute, you could bring a suit in New York, assuming you have personal jurisdiction over the party. And federal courts are courts of limited jurisdiction. So basically, there's only two ways you could file a suit in federal court. If it arises out of a federal question, so if it's a copyright dispute or antitrust, ERISA is actually preempted. You can't even, if it arises out of ERISA, you can't file in state court. You know, there's a way to dismiss that right away. Or if there's diversity, and diversity is diverse on all sides. You should really look at, before you file any suit, it's 1332A. Because diversity, it gets very confusing. It's diverse on all sides, but if you have a corporation, for instance, individuals is simple, it's where they reside. But a corporation, it's their principal place of business and where they're incorporated. A partnership is presumed to reside in any state where the partners live. A limited liability company, it's where their members reside, so it really does get confusing. So before going to federal court, because it's embarrassing from a client standpoint if you get there and there's really not diversity, and then it could be sent back down. So just be sure that it exceeds $75,000 and it's diverse on all sides. And you can't have two, I just had this too, you can't have two foreign defendants on each side. It has to be on each side someone from a different state and the foreign defendants. So just be aware of that.
So now you've filed the complaint and you filed the answer, and issue is joined, as we say, meaning that you know what the denials and admissions to the allegations are, and what do you do next? Obviously, the next stage is discovery. And what you do in state court, they're a little different, state and federal court. In state court, the rule is he or she who serves a notice of deposition first gets priority. And the first opportunity to serve a notice of deposition is with the answer. So whenever I serve an answer in state court, rest assured that there's going to be a notice of deposition that just gets served to preserve priority. I want to take the deposition of the other side before they take mine in almost every case. I want to know what they're saying, what their story is. So I will serve a notice of deposition with the answer, and I will also, we serve discovery requests, interrogatories. I'm not a big fan of bill of particulars. I think they're sort of a waste of time. And sometimes interrogatories are a waste of time, especially when you're dealing with documents, but document requests are crucial. And when you're doing discovery, state or federal court, or arbitration for that matter, you ask yourself, what documents do I need at the end of the day when I'm putting my client on the stand to have him testify in this case, or to cross-examine them? Do I need email, communications? Do I need contracts? What do I need? And what don't I know? And so there's a lot of, certainly party discovery, there's a lot of thought that goes into what your discovery request looks like. They all have common requests, communication between the parties, agreements between the parties, but you go beyond that. And that's a process that you really have to think through, because at the end of the day, you don't want to be at trial saying, oh my goodness, I didn't ask for this, and I can, I really need it. So federal court is a little different. Do you want to, I'll keep going, I guess. There's a Rule 26 in federal court, which essentially requires you to give, it's more structured in federal court. It requires you to give a list of witnesses and essentially areas of documents that you would, categories of documents that you possess to produce. You have to file a Rule 26 notice, and in federal court, there'll be a Rule 26 conference shortly after the filing of the answer, many times before you even file an answer, because the federal court judge wants you before him or her to understand what the case is about. State court's not like that. State court will not have a conference until you actually ask for one, or there's a motion which essentially gets the judge going. You file in state court a complaint, and not until you file a request for a judge, it's called an RJI, a request for judicial intervention, does a judge even come into the scene. So you could literally be in litigation in state court for 1.5 years without a judge. Federal court's not like that. You have a Rule 26 conference immediately, a judge is signed immediately, and judges are very much on top of that. I will tell you that in state court, there was a revision maybe 15 years ago, where they have a commercial part in every state court in the county. So New York County, for example, there are 6 judges who only handle commercial disputes, which is a great thing because I don't really do personal injury, and there's a lot of personal injury litigation, malpractice litigation that's handled by the other judges. The 6 judges that I go before, predominantly deal with business disputes. So it's sort of a level between the federal court sophistication and the state court lack of sophistication. So without insulting, I probably just insulted every judge here, or every judge in New York. But no, seriously, you do not want, and it's not. I don't want a medical malpractice judge to be deciding my issue over derivatives and securities and options and naked calls and all that wonderful security stuff. They just don't know it. So it's just not their expertise. State court judges in the commercial part know more of that, and federal court judges certainly know that because they have security. There's 10B, there's RICO, there's all kinds of federal statutes that deal with that. So as well as federal court judges, most of you probably know, have criminal cases. They do civil and criminal. State court's divided. Civil judges for civil cases, criminal judges for criminal cases. So many times you go before any federal court judge you go before on a securities violation, rest assured that judge has probably put someone in jail on a 10B violation. So, there's a level of seriousness when it goes to federal court, which I think is more, you have to just, keep your ears up for.
Right, and one interesting part about New York practice, the Supreme Court used to be like this, but if you're in civil court, you get a different judge every single time, which is, it's crazy. So you have to, basically, the judge, when you're going before them, has no idea what the matter's about, whereas if you're in Supreme Court or federal court, obviously they're familiar with the matter because they've been with it from the beginning.
And over the last couple of years, there's a tremendous lack of civil court judges. Civil court cases are below $50,000.
Yeah.
There's a lack of civil court judges. So not only do you get a different judge, but many times things that are on get adjourned because I think there was less than 5 or something recently. So they're actually bringing visiting judges into civil court. It's part of the budget and the lack of the ability to get civil court judges. So I'm not sure how it is now, but the most recent time I was there, it was pretty bad. Mm-hmm. It was pretty bad. But that's, the discovery is a function of what court you're before. And it's important that you really get your document requests out and you get your deposition notices out and you get your interrogatories out. You also want to, there's 3 different areas of discovery. One is a party discovery. You want to get the discovery from the other side. The second is from your own client. You have to go out and you're going to get requests anyway. You have to get your client's financials if it's a financial dispute. You have to get everything, all the communication, so you know your story before you produce it. And then the third area is non-parties. You actually, if they're friendly, you can interview them, maybe get something voluntarily, maybe and get an affidavit. Don't have someone friendly testify in court without something to make sure that they're going to testify the way you want them to. And you also can use subpoenas. So if you have, for example, a financial dispute and you want to know what the banking relationship is with the plaintiff or the defendant, serve a subpoena on the bank, serve a subpoena on the brokerage firms, and you will get monthly statements, you'll get checks, you'll get whatever you want. So those are the 3 areas. You just have to sit down and really say to yourself, what do I need to prove or disprove this case?
Mm-hmm. And one interesting thing about the difference between state and federal, if you know that if you do have a way to get into federal court, and a lot of your third-party witnesses are outside of New York, it's much more complicated to get discovery. Under the federal courts, basically any federal court has jurisdiction within 100 miles. So if you're in New York, Southern District of New York, and a witness is in California, you could commence a limited proceeding in California to get jurisdiction over that witness. If you need documents or testimony, in New York, it's called a commission, which it could be a long, complicated process because you have to get permission.
You have to start a lawsuit if I have a witness in Florida I want to depose, I have to actually start a lawsuit in Florida. It's a simple lawsuit, but you have to start it. And you have to get letters rogatory or a commission and get the state court judge in Florida to issue a subpoena for that witness. So it's a bit of a burden, it's a bit of a pain, but if you need to do it, you need to do it. Mm-hmm. Interrogatories, you want to go? Well, let me just mention interrogatories. Federal court is limited to 25 interrogatories, and judges are very strict about that. So if you have, I had just last week a plaintiff who served 15 interrogatories on me, but they had 4 subparts, and each one of them asked for my client to delineate 200-some charges. So it ended up being, 800 interrogatories, and you can just literally respond that it's beyond what's allowed under the federal rules, and you don't have to pick your 25, you just reject the interrogatories. There is a 25 limit, including subparts. In state court, there's no limit except for the commercial part. The commercial part has that same 25 limit, but the other state court judges, you can have 50, 100 interrogatories. I'm not a big fan of interrogatories because what they are essentially is the lawyer writing down an answer to protect his client, his or her client. You get much more with a deposition than you do with an interrogatory, but they are a tool.
And they're less money. I mean, if you just want identification of witnesses and addresses, that's basically what the interrogatory, the main purpose it'll serve, because there's only so much a lawyer could hide through an interrogatory. If you're asking, does the defendant reside here, identify every potential person with knowledge of this dispute, that they'll list the names and addresses, so you could subsequently depose them. And I just want to go back to the difference in discovery between federal and state court, because as Richard said, in federal court, it's much more organized. You can't start discovery before it's called a meet and confer. It's under 26F. So you're required to sit down, and when I say meeting, it's really, it's a process. It's not just one meeting. It's not supposed to be. Usually it's in person, and you'll address almost every aspect of discovery. Basically, how electronic data will be searched. What will we search? What's the scope of our document request will look like? I mean, that's an ideal 26F. A lot of people don't do that. I mean, it's interesting, with the amendment of the federal rules in 2006, the rule was amended to make litigation opponents more cooperative. So there wouldn't be this trench warfare mentality, like hide the ball and let's just like make this as expensive as possible. But a lot of older lawyers still have that mentality. But I really think that 26F, if you could make the most use out of it, is helpful because it eliminates a lot of disputes down the road. So you sit down with opposing counsel, you'll say, okay, we're going to agree. There's forms, but basically down to the metadata that will be produced when you exchange discovery. Because lawyers will fight over anything, so as much as you can agree to in that 26F and put it in writing, that is helpful. And then, as Richard was saying, you have the opportunity to, if you want to limit under the federal rules, there's limitations in interrogatories, there's limitations for depositions, 7 hours in one day. You could stipulate out of that and say there will be no limits with respect to discovery, so you don't have that dispute down the road. So I think that's just an important thing to mention.
Yeah, and on emails, you can have, I have a case right now with a Bloomberg company, and I wanted emails literally worldwide, into the Philippines. And many times you will need to come up with search terms, and you have to think, what words do I want them to search for in their email system to produce? Because many times the emails are just so voluminous that they're not going to produce everything. They ended up producing 8.5 million emails. Good luck, enjoy looking through those. But that was after we came up with a limited search term. So you really need to figure out what words am I looking for. If it's a securities case, am I looking for words like suitability, unauthorized trading? Am I looking for emails to and from certain people? If it's an employment case, am I looking for something, pregnancy discrimination or some words that you can really, retaliation or harassment, something you can really limit it. You don't want to limit it too much, but when you're dealing with big, mega billion-dollar companies, you will literally, they're not going to, companies will not, my clients or on the other side are not going to sit there and say, listen, we're going to produce to you, just trillions of emails. So it is a process. When you meet and confer, you really have to think to yourself, what words do I want? And you could always amend it, but that's at least gets the process going, right. The discovery process.
And just a tip, don't ever agree to search terms without testing them, because basically there's case law that says you're bound once you agree, and there's third parties that they agreed to search terms. It cost them millions of dollars to make a simple document production because they agreed to a word like money. Obviously, it's not a smart word to agree to. You should limit it like money within 5 of whatever an issue is in dispute. And the other thing about the 26F, just one more thing, is that I always try to have a technical person there, if someone from our IT department, because there are a lot of issues that come up that I just don't have the background or expertise to address, and you should recommend that the other side bring someone from their department as well, so they could speak the tech language while you know the law.
You try really hard to resolve your discovery disputes. There's not a judge in this land that enjoys discovery disputes. They hate them. They loathe them. He wouldn't produce this document. He wouldn't answer this interrogatory. Judges hate them. You deal with it. I deal with it all the time because I have adversaries I can't agree with. I try my best to keep the dispute between the lawyers civil. I mean, Dana and I had a case, as she mentioned. Don't ask her who won, by the way. And we had a great relationship. So we keep it civil because our clients generally, by the time they come to us, are pretty pissed off at each other. And you want to try to resolve your discovery disputes as best you can. You give a little, you take a little, because you do not want to go before a judge. Judges don't want to sit there and say, well, interrogatory number 7, interrogatory number 9, why won't you answer it, and why is it overbroad? So try your best to work those things out. It's also a tremendous amount of time that's wasted if you can't, unless it's something obviously really important. If someone says they're not going to give you emails, or they're not going to give you the emails you need, you may have to go to court. But you should try by conversation, you should try by emailing yourself, by letters saying, confirming what you can agree to, and trying to put it in issue. So if you are before a judge, and I assure you he or she will be pissed off that you're there, you could say, Judge, I've tried. This is the steps I've taken, which will sort of reduce it. It's just very frustrating, and judges are so busy, they don't like getting bogged down with disputes over interrogatories. It happens. Depositions. It happens. Depositions, moving on to that, the general rule of depositions is every single objection is preserved for trial, except form. So you really are allowed to tell your client not to answer a question under only 2 circumstances. One is if there's an attorney-client privilege, and 2, if there's a Fifth Amendment privilege. Now, obviously, if they ask about something which is way off the beaten path, the sexual relationship with some woman or something of a man, then you could maybe object to that. But generally speaking, courts, you have to let pretty much everything be answered. Many a times I will be in a dispute with my adversary where he will not let his client answer. I have the phone number of the judge right there. I will call the court from the deposition. I hate doing it, but I do it. And we tell the court, Judge, this is my position, this is their position. The judge will rule right there on the record, on the phone, at the deposition. I try not to do it because I tell my clients, listen, if you're a plaintiff and you're suing, you're letting them know your tax returns, you're letting them know your income, you're opening up your business world to them. And if you're a defendant, you're being sued. It's pretty similar. So the rules on depositions are very, very broad, as are all the discovery rules. The relevancy standard is if it's relevant or likely to lead to the discovery of admissible evidence, and judges will generally allow things to be produced.
Right. And also, just with regard to discovery disputes, this is something I probably should have mentioned at the beginning. As soon as you find out who your judge is, not every judge, but pretty much every judge has their local practices. So you should always look on the websites of the federal courts or the state court and look what the judges' practice are with respect to discovery disputes. Most judges require you to confer in good faith and have an affirmation stating, I reached out to opposing counsel, I tried on this date to resolve it. That's why we came to you. So, and you could get in trouble for not doing that. The judge will not be happy. So look at the rules.
And they also have, many judges, federal court especially, have what's called, you have to write a pre-motion letter. You don't just make a motion, especially a discovery. And some judges have page limitations. I was before Shira Schindlin 2 weeks ago, federal court, and it's you're limited to 3 pages. My adversary wrote a 4-page letter. I responded with a 4-page letter, and she was upset. She said, listen, I have a 3-page limitation. I'm ripping off the 4th page. So you have to really, those judges, they really do abide by, some more stricter than others, their individual rules. Every judge in federal court has his or her individual rules, whether you're in New York or whether you're in Iowa. So you have to really look at them, and if you make a discovery motion and you should have written a letter, I assure you that judge isn't going to be happy. Right. So you have to look at that.
Right, and the other rules, if you're in New York State Court in the commercial division, there's separate commercial division rules, which you should be aware of because there are some differences between the CPLR and the commercial division rules. For instance, under the CPLR, if I'm served with a complaint and I file a motion, it stays all discovery under 3214. But under the commercial division rules, it's discretionary. So you have to go to the court and ask them to stay discovery if you want to do that. So you should always look at those, and that's you could find those online as well.
Then we go to experts as far as discovery goes. You have to decide early on in the case if you need an expert. Many cases need damages experts, and there are economists, there's damages experts, there's all kinds of future value experts, and you have to really do a lot of digging. I call friends, I call colleagues, I use some expert many different times, but preparing experts, it's an art, not a science. You have to really think through what you want from them. Remember, the expert is not necessarily it's your client's relationship. So anything you give to the expert gives to you, is not necessarily protected by the attorney-client privilege. So you have to think through, anytime you write an email to the expert, anytime you get a document from the expert, make sure that it may very well be discoverable. So getting experts is essentially, in many cases, is a huge step. You need to get a good expert. You need to make sure they're prepared, and you need to make sure that they have expert reports in federal court, state court. They will give testimony and/or give reports, and you have to make sure that their deposition they're good, because the Daubert motion, there's a U.S. Supreme Court case called Daubert and its progeny, which essentially held that if, in fact, your expert's testimony is not based on factual scientific evidence, it will be rejected. And the last thing you want to do, it's happening to me right now, where you have an expert that was thrown out by the court before trial. It makes it a very tough case. I have a case right now involving the Bloomberg Company, and the EEOC is suing Bloomberg Company for several women pregnancy discrimination. It's the EEOC, my firm, and another small firm. And Bloomberg made a motion to exclude the EEOC's expert, and motion was granted. So now the EEOC is sitting on the eve of trial. We're about to hear summary judgment motion decisions, and they don't have an expert on some very important issues, which puts a tremendous hamper on their case. So you have to make sure, you have to be familiar with Daubert and make sure that you really know your expert's basing his information on reliable data, and that it's essentially a scientific analysis, even if it's monetary. It has to be based on real data.
Right, and just so you're aware, with experts, New York doesn't follow Daubert. They follow the Fry standard. I won't go into the difference, but you should just be aware of that if you're in state or federal court. And just to expand on something Richard says, the federal rules were recently amended, so it provides more protection, attorney-client protection, between the expert reports and the attorney. So that's in Rule 26 if you're ever in federal court. Mm-hmm.
You want to go to summary judgment motions?
Sure. Mm-hmm. Oh, you want me to do it?
Yeah,
okay.
Whatever.
So basically, when I move to dismiss a complaint under the CPLR or the federal rules, it's a high standard because there's limited documents I could introduce to file my motion to dismiss, and everything in the complaint is presumed to be true. You could produce documents that are incorporated by reference or integral to a complaint. Under New York, you could induce, there's documentary evidence, which is basically totally refutes the allegations in the complaint. But for the most part, it's difficult, because even if you have a great document, you might not be able to get it in on a motion to dismiss, or the judge will convert that to a summary judgment motion, which you don't really want, because then discovery starts, or basically she'll decide just on the papers you submitted. So after you go through the motion to dismiss and you go through discovery and you have all your evidence, you could file a summary judgment motion, and at that point you could introduce and attach to your summary judgment motion everything that you think will help your claim. And the standard is there's no genuine issue of any material fact. So basically, even assuming everything in here is true, you can't go forward, so end this case right now. And that's basically, I'll file the brief, it's back and forth, and summary judgment could be granted. The same thing with motion to dismiss with respect to some of your claims or all of them. But if it's denied, then you basically go forward to trial. So do you want to say anything else about summary judgment?
That's pretty much it.
Yeah.
Summary judgment is a great way to get rid of a case on the defense side, because many a times you've taken the depositions of the plaintiff and or other people, and you find that they say things which, for example, in a fraud case, I never relied on it, or I knew, or something like that. And those are the type of quotes you put right in your motion for summary judgment. And if the plaintiff, if you can't show the 5 elements of fraud, that case will be dismissed in summary judgment, especially with a strong judge. So they are a very effective means on the defense side to just be done with the case, and it's a pretty big win. You don't have to go to trial. On the plaintiff side, you want to get past that motion. You get past that motion, you have a jury, or a non-jury, many times a jury. And when you get to that point, defendants get more and more nervous. With a non-jury in particular, you have a judge who's going to render a written decision. So if you represent a company, small or large, private or public, and there's going to be a written decision about their practices, which will follow it forever, there's a very good chance that that company is going to want to get rid of that case before trial. Jury verdicts, for different reasons, companies want to get rid of cases because you just don't know what a jury's going to do. You're literally at a roulette wheel. So for a plaintiff, if you can get past that summary judgment motion and you defeat it, either all of it or part of it, and you know you're going before a jury or a judge, that is really the good time to start talking settlement, because the defendant basically has shot all of its arrows out of its quiver and there's no more arrows left other than trial. We should turn a little bit to settlement and mediation. I'm a huge proponent of mediation. There are different FINRA, JAMS, the American Arbitration Association, the courts themselves have mediation. Many courts, it's mandatory. State court commercial now, it's mandatory, and federal court, I'm not sure if it's mandatory, but I know
it's an option.
It's an option,
yeah.
but listen, the mediation is as good as the mediator is. Almost like a course in school. It's as good as the professor is. But if you have a good mediator, that's a very effective way of disposing of a case on both sides. So mediation, generally the process is you have to educate the mediator. You both do pre-mediation briefs. And then you sit down, and it's essentially a two-step process. Step one, generally, is everyone in one room, where and by the way, for those of you that don't know what mediation is, I assume everyone does, it's essentially a settlement meeting with an independent third party in the room. That's all it is.
It could work, it won't work. You could spend the whole day where you're just sitting in a conference room and the mediator is going back and forth, and then you just go on and you keep going with the case. So
Right. So the first session of it is essentially everyone's in the same room, and I call it bloodletting. You tell the other side why you're going to win, both of you, and then the mediator will separate you, and the predominant part of the day, from let's say 10 a.m. till 5, it's called shuttle diplomacy. The mediator will literally go into your room, talk substance, and go into their room, talk substance, and go back and forth. And as the day goes on, you start moving from substance to money. Well, how much do you want? Well, how much can you pay? And an effective mediator can get rid of, many mediators that I've dealt with get rid of 95% of the cases that come before them. So mediation is a very strong mechanism that courts love employing to move cases on and get rid of them. Many times, you're right, at 5 o'clock, 6 o'clock, it doesn't settle, but a good mediator will follow up with phone calls and will try to continue to settle that case. I have a few now that went to mediation, haven't settled, but they're still in the process of talking to and dealing with the mediator and seeing if they can settle. But I'm a big fan of settling the case. It just gets rid of the problem on all sides. And a good settlement is, I tell people, a good settlement, a bad settlement is better than a good litigation, because you just want to get rid of it. You're going to walk out of the mediation, your clients are somewhat disappointed. Generally, rarely do you say, yeah, I won, but it's a bird in the hand. It's over with, you close that chapter in your book and you move on. So they're very effective means to dispose of litigation.
Right, and there's also private mediators where you just pay them by the hour, and I've done that too. And again, you have to seek recommendations. It's better to have a mutually agreeable mediator that you've worked with before, and the other side is amenable to. I've had my last one brought cookies. She started out with, that was her she brings baked goods to the mediation to soften everyone up. But yeah, they all have different approaches. But yeah, and the other thing about settlement is it's a tactical. It's a tactical way. You have to know when to bring it up. So if you're a plaintiff and you start with me a complaint, even if you think you have the weakest case, to come to me right away and say, let's settle, I'm going to smell weakness. So usually you have to act, if you're the plaintiff, aggressive and say, I'm willing to litigate this whole thing, and then put it in a position where the case is ready to be settled, unless you really just.
And now you go to trials, pre-trial, federal court. It's a pretty big, voluminous task to perform before you go to trial. There's something called a pre-trial order. Judges don't like surprises at trial. As much as we watch, I would say Perry Mason in my day, but that's obviously a long time ago. But as much as we watch the law shows, you really don't have many surprises at trial. Very infrequently. You have to have all your documents marked and you have to have them ready as evidence, and you have to have the other side's objection already. So if I have a document I want to put in, and the other side wants to object for lack of foundation, that objection has to be in the pretrial order. You have to have all your witnesses listed and the subject of their testimony. Your expert testimony has to be revealed. You have to reveal any contentions you have. You have to stipulate as to facts. The parties entered an agreement on January 1st. the parties entered into an amendment of the agreement that all has to be done, and stipulate as to exhibits where there's no objection. So judges make you do, the commercial part in state court as well, make you do a good amount of work before trial, especially when you have a jury, to make it easier flow for the jurors. They do not want you standing up and arguing for 10 minutes about the admissibility of a piece of evidence with, jurors sitting there. They just really, the rules have, I think, advanced tremendously to assist in that process. I'm a big proponent of that. State court has certain individual rules of judges. They have the same thing. They have a pretrial order, and you have to make sure that the other side knows what you're asking. And if it's not, and if you don't put a witness in the pretrial order, or you don't object to an exhibit, the judge could very well say to you, you know what, that witness isn't in there. It's not for rebuttal. You're not putting him on the stand. So a lot of work has to be done in the pretrial order. In the state court, it's a little more ambush because it's not as, most judges don't have to you don't have to give that much of a preliminary indication as to what the evidence is and what the testimony will be. And in arbitration, it's almost like the Wild West. There is a FINRA arbitrations, of which I've done a lot. There's what's called a 20-day exchange, which is 20 days before the hearing. You have to give a list of witnesses and just categories of documents. But you really don't have to go to the length that you go to in trials, nor does the other side know what your witnesses are going to say. So an expert,
maybe in what order they're going to testify.
And in what order they're testifying, yeah. So you won't even know what their expert's going to say until he takes the stand. So it's definitely a little Wild West. I think it's more fun that way, more like you're on a cliff. But I do like it, and so there are varying degrees through different jurisdictions and processes that require you to do all kinds of things pre-trial.
Yeah, and arbitration, there's really no evidentiary rules, pretty much. I mean, it is the Wild West. You could anything goes. So yeah, I guess it is fun in a way. But I mean, there's my last arbitration had 3 arbitrators, and one was sleeping the whole time. So it's like
yeah, I once accused an arbitrator of sleeping. I'm not sleeping, but the preparation of the trials is huge because you don't want to find any surprises, and you need to make sure that you're jury or non-jury ready for whatever's going to be thrown at you. And if there's a document, if you're not in federal court and you're in state court, and there's a document that they want to put in, which is is a hearsay document or lacks foundation or has an evidentiary problem, you got to be ready. You got to be ready to jump when they put that when they try to put in evidence, as well as in many instances if it's a complicated issue like the dead man statute or something, just very very more esoteric. I will have a 1 or 2 page memo and even case law saying, Judge, under Smith versus Jones, you can't put that document shouldn't go into evidence, and you really tremendously prepared you have to be because you really do not want the documents to go in which shouldn't go in.
Mm-hmm. Right, and just to elaborate just a little more on the jury pool, in New York, the jury pool, this also could formulate where you want to go into federal or state court if you have a jury trial. In New York, they come from New York County, the jurors, and in federal court, they come from all over the district. So you get a much broader jury pool. So depending on what case you have, you might want to take that into consideration. I don't know if you've noticed any difference in awards between the
No, I don't notice difference in New York, but if you're I tried a case in Houston, Texas, and I'd say that none of my jurors had driver's licenses, which made me really nervous. Because to me, if you don't have a driver's license, I don't know if you really have that much of an education. Maybe I was wrong in making that correlation, but I made it. And I was very nervous in Houston, Texas, and representing a broker-dealer against an oil company. So settled that case quickly. But
nothing good happens in Texas. That's the motto in New York, if you're in New York.
There you go. So sometimes in your other jurisdictions, I have a case right now in Boise, Idaho. I've been flying to Boise a lot lately, and it can't be more conservative. And we joke about it. And I have the SEC is suing a client of mine. And I'm in a pretty good jurisdiction because they don't like the federal government there. And we'll see what happens. It's probably going to go to trial sometime in the late winter, January, February maybe. But you have to size up your jurisdiction. For plaintiffs in personal injury cases, Brooklyn's great. The Bronx is great. Westchester and Suffolk and Nassau stink for plaintiffs in personal injury cases. So you have to sort of do the same analysis as to who your jury is going to be. Then we have, many times, so if you have a non-jury trial, a jury trial, you essentially have to, there's a lot of other work you have to do. You have to come up with first of all, you have to pick a jury, then you have to come up with, which is voir dire, essentially, you have to select a jury. In state court, you really do it yourself, and in federal court, the judge does it, although you're there. you're involved in it, but you're much more involved. In state court, you literally do it without even a judge present, the jury selection. But with a jury, you also have to spend a lot of time on the jury charge. And one thing lawyers don't think through is, how do I want that charge to be? If I'm on the defense side, I want as many questions to be asked of that jury as possible, because if they ever get to a no, then they're not going to give a result. So if there was a fraud, was there a material misrepresentation of fact? If yes, go to question 2. Was it as to a present fact? Sometimes the judges won't let you do that. If yes, go to question 3. And if you try to, on the defense side, make it a very long questionnaire, you're hoping that they finally hit a no. On the plaintiff side, you want it to be short. Is defendant liable for plaintiff's damages? Then you just go right to the heart of it. So there's a lot of work on the jury trials, because the charges and the jury questionnaires are the actual verdict form are very important. Non-juries, judges make you do the work. You have to do not only pretrial briefs, but you have to do post-trial briefs, because they want you to tell them why you win, and it's a lot of work for other reasons, more research and writing.
Right. I mean, basically, after the trial, you have to go through all the testimony and do a subsequent post-trial brief, so the judge, to make it easier, basically, for the judge, as Richard said. So it's very time-consuming, and that actually could happen. I've had arbitrators, when you're in arbitration, have you do that as well after the arbitration is over. So it's just something to be aware of. Do you want to go to appeals? Or
Sure, we'll go to appeals.
Okay.
So appeals, well, Dana, you want to go?
Yeah, I mean, appeals basically, in New York, the difference between federal and state, in New York, you have a right to appeal if it's a non-final judgment. So a lot of people also like to be in New York if they have an intermediate issue that they want to go up to the court of well, I guess it depends where you are, but the intermediate court, right?
Yeah, you can appeal anything at any time in New York. You get a decision, you can appeal it that day.
Right.
Federal court's not like that.
Yeah, so federal court, you have to wait till the end. It's from a final decision. So, so basically, in federal court, you would go up to the Second Circuit, and basically, it's a big. I mean, it's a big deal, but it's also, when you're appealing in federal court, there's a lot more disparity between the circuits. You would follow the Second Circuit, but if there's a split in circuits, there's a lot more to research, or if it's an unsettled issue. In New York, there's less issues that are unresolved. There are a few, but basically because it's a one-court system, and the Court of Appeals tries to limit the amount in disputes among the departments. So it's 4 departments, so that's who you would appeal to based on where your court is. So you can file a notice of appeal, but you don't have to. It's called perfected for it's 9 months, right? You have to perfect it. So you could basically always file it if you think you want to appeal, because you have 30 days basically from the time of the judgment. It's service of the judgment. Look at the rule. I think it's from service.
Yeah, timing and appeals is very, very important.
Yeah.
If you miss it by a day, courts will say, sorry, you're out of the box. You can try to make a motion to get back in, but you're out of the box. So yeah, timing is very important. And in federal court, they really don't have concurrent jurisdiction. You're either in the Southern District, or the Northern District, or the Western District, or the Eastern District, or you're in the Second Circuit. State court, you could be in both at the same time. You could be arguing an appeal on the same day. You can be going down to Supreme Court and in the same case. So there's concurrent jurisdiction there. And you know, it's like anything else. It's a brief, and you have to take everything below and argue it above. The first department is on, I think, 23rd Street and Madison Avenue, gorgeous building. And all the departments, there's 4 departments, as you all probably know, have their, their day of their couple days of the week where they get appeals. New York County, in New York, there's a lot of appeals. And you go and you have that green light and that red light, and you argue just like moot court for your 5 minutes or your 8 minutes, and then you're done. And I much prefer trials because there's no time limit, and it involves, I think, a little more, I guess, the different type of talent. But appeals are tough because judges may throw things at you which don't even relate to the appeal, and they need an answer. So they can be very demanding. Right,
and you'll know like your panel beforehand, so you always try to research if they have any decisions that address these issues. So the judges like it. They all they have egos, so they like it if you say, oh, in your decision, blah, blah, and just be aware of that and their backgrounds. It's the same thing with the Second Circuit. You'll find out who your panel is beforehand.
Right, and appealing an arbitration is very different than appealing a trial. The arbitrations essentially are called the snowball's chance and hell's standard to get them overturned. I, of course, had one vacated twice against me. So that notwithstanding, it is very hard to have an arbitration, vacated. Go to Charlie Ramos. But you essentially have to show in an arbitration that the panel had the law in front of them and they intentionally ignored it. And it's a tough standard, other than not like trials. The court system tries to give a tremendous amount of latitude to arbitrations. So once an arbitration decision comes in, you can try to move to vacate that decision, but it's very, very hard to vacate that decision. It's essentially that the main standard is that the panel manifestly disregarded the law. Mm-hmm. Panel, this is the statute of limitations, it's 3 years, and the panel says, you know what, I'm ignoring that. I know it was brought 5 years ago. I'm bringing that. I'm letting him bring that case. That's the type of thing that a court will overturn, and you go from your arbitrations to your Supreme Court, then from the Supreme Court to the or federal or the Southern District, then from there to an appellate court. But arbitrations are it's just really, really difficult. Once you get a decision, you get a decision.
Right, and always when you get an arbitration decision, move to confirm that award in the Supreme Court. So that's the way it's enforceable by a court.
Right. We should talk about collection a little bit because we really don't. It's one thing they don't teach. I didn't think they taught me in law school. You get a judgment for $20 million. Great. So there are a lot of different collection mechanisms under the CPLR, and essentially the first thing you do is you need a judgment. You got to get that judgment. Once you have the judgment, essentially the doors are open. There's federal statutes which protect privacy when you don't have a judgment. Once you have the judgment, there's more leniency. You can learn more about the defendant, as well as you can serve. There's all kinds of mechanisms. There's a restraining notice you can serve on a bank account. You could serve, if they own personal property or real property, there are ways to go to the sheriff or go to a marshal and serve. Actually put a lien on the property. There are ways to take property. There's all kinds of mechanisms which you really have to, one of the things that I am always worried about is when I get a case, and going back to the beginning of our conversation, if I win, so what? I just settled a case in August at trial, and the defendant was supposed to pay, I think first week of September, never did. And I knew from the beginning of this case it'd be a toughie. The defendant lives in British Columbia, so now I have to take that judgment, get a judgment in Canada, and get it enforced. So collecting is a long, arduous task, and you don't want to be in a position where you got a judgment for whatever and you haven't collected. You also can go after, I recently did, banks. If I serve a restraining notice at a bank and the bank mistakenly doesn't find the account and releases the money, you can actually, the bank, you can add them as a potential defendant to collect that money from if they've messed up. But collecting is not easy, and that goes into your initial analysis. If you're suing a Bloomberg company, they have money, billions. But if you're suing a little mom and pop, and try to learn the history of that mom and pop, you don't want to find yourself 2 years down the road winning, and putting your judgment against the wall. So it's just, there's all kinds of mechanisms that New York gives you, all states give you, to try to collect on that judgment. Do you guys have any questions?
It's a lot. I mean, actually, it's funny because I was going through this outline, and every topic could be its own presentation, so it's a lot thrown at you, but the intention was just to give you a broad overview of the whole process. Mm-hmm.
Go ahead. You have, I thought it was 10. You have, I think it's 10 years to execute. But the problem is finding the assets of that defendant. You have plenty of time to do it, but it may not be easy, especially where, in many instances, I've had the company's gone. If the company's gone, then you have as long as you want. If you have an individual, I had a judgment against Jamal Barrows, a.k.a. Shine, if you know him. He's a rapper with P. Diddy, and he was in jail for I don't know how many years after he was involved in the shooting on around here in Midtown. And so he didn't have much money. Well, lo and behold, while he was in jail, he did an album, and he has money now. So that judgment probably is 8 years old, and I'm going to finally be able to collect on that. So you got to pursue it. You got to pursue it. I recently got a money from HSBC because they released money mistakenly to a defendant and a judgment against, notwithstanding the fact that I had a restraining notice. But they're out there. And there are people out there actually who I've employed, who I've actually used, who are just do collections. They're very familiar with the processes, and I have some friends, if it's a difficult case, I'll say, you know what, collect and we'll figure out a fee, sharing, because I just don't have the time or the patience. So there are people out there that just do collection, but yeah, and I think you can actually extend that 10 years, maybe for another 10. But the problem is, if you're dealing with a company, I have one now with a company out in Nevada, they're gone. And I have a judgment for I don't know how many hundreds of thousands of dollars that's never going to be collected again. So, for clients. So yeah, you got to be really, they don't teach you that in law school. Getting the money is, for the plaintiff, the most important thing. Go ahead.
Can you give us an idea of the size of the support staff that you devote to cases, and maybe building on that, the role that recent Washington graduates would play in such a support staff role?
I don't know if I heard the question. Do you?
The question was the role.
How many people do you devote to these cases? How many people?
Do you depose?
How many people do you devote to a case, to work on a case?
Oh, well, go ahead. It's probably a different answer.
Different answers. I've always been at large law firms, and it also depends on the case and the client, how much resources the client want to devote to a case and how much is at issue. But on a big case, I've been on cases where there's been 6 to 10 lawyers. I mean, with the amount of documents you have to review, like that's where the junior associates a lot of times come in. It's not glamorous work, but you do learn the most about a case by reviewing documents. On a smaller matter, like an arbitration, I'm working on one now. It'll mainly be one junior person, me, and maybe another person supervising the case, and then those types of cases, the junior person gets a lot of responsibility. So it really just depends on the matter, and I'm sure your firm it's different because it's
My
so
firm's
much smaller.
it's different, but yet it's similar. I generally have, my cases are generally smaller than Dana's cases, so I generally have 2 to 3 people at most. However, I do have some large cases, and many times in large cases there are other law firms that work with me. So, for example, my case in Idaho, I think there's probably 10 different sets of law firms, one of which is K.L. Gates out of Washington. And between, because you have several defendants, the SEC suing, so you have somebody representing I was representing everyone. Now I'm representing just the board management, but there's a different law firm representing the company, a different law firm representing some ex-officers. So sometimes you can pool your resources. It's important you enter into a confidentiality agreement, a joint defense agreement, so you can share everything. But I use K.L. Gates, for example, in that matter, or my local counsel for that matter. So there are ways to effectively handle cases, or my EEOC case, for example, with Bloomberg, with other law firms, and it's essentially division of responsibility. I think I have 5 lawyers in my entire firm, so if I'm going to have to, nobody's going to come to me with a $4 billion case and with 8.5 million emails. Even though I was involved in that case, it's also the EEOC. So mine are much smaller staff, generally 2 to 3 people. One other thing we should touch on is when you do settle. Settlement agreements are very important because they will define the terms of the parties. Whether you want, obviously you're going to have a release and you're going to have a dismissal and you're going to have a payment. But other terms are, do you want a non-disparagement clause? Do you want the other side to go to the press and, or not go to the press and say this case is settled or say bad things about you? Confidentiality provisions. There are other provisions as to jurisdiction, as to, I can think of almost anything. There are, in the employment context, there are very specific terms that must be in a settlement agreement for them to be enforceable. You must say, if you have an age discrimination case, it must say in the release, not that we're settling all claims, but it must also say, including all claims under the ADEA or under Title VII. You have to actually list those in the release, or they're not effective, and you have to also give, depending what type of case it is, whether it's age or race or sex, you have to give a certain amount of time for the plaintiff in the agreement to essentially rescind it. So settling cases is, I've been involved in many litigations where the settlement didn't go well, and you find yourself right back in court fighting over settlement agreements. So it's very important. Also, if you settle at trial, you put everything on the record. I put everything on the record because I want my client to stand there and say, yes, Your Honor, I understand the settlement terms, and I agree to them. I did it voluntarily, and my lawyer did a great job. Judges always make the client agree to that. So this way, you're protecting yourself and you're protecting your client if you get it on the record. But settlement agreements are a source of many litigations. So it's important you put that, that you really do a good job in negotiating the settlement agreement.
And then also, just so you know, some settlement agreements have to be approved by the court. Class action settlements. You settle with the SEC. If you've heard about the recent decision by Judge Rakoff, who rejected the SEC settlement with the Citigroup. But I mean, you should just be aware of that as well.
This is sort of a two-part question. Have you seen a big shift in e-discovery, and do you think it's useful for young attorneys to have a little bit of background and knowledge in that?
Definitely.
And what other skills do you think are most important for young attorneys to bring to a courtroom?
You want to take a
Yeah, no, I mean, e-discovery, I'm the e-discovery attorney of my department. It is such a critical skill. Now, if you could market those capabilities, I mean, they're basically by looking through the recent decision, Judge Shinlin is the forerunner, basically, in e-discovery. So I would read her decision. She's written a treatise. I think, are most law schools now teaching a class in e-discovery? Is that? No, I'm so surprised about it. I mean, they should, but yeah, it's such an important area. And if you could develop an expertise in that area, and you'll be golden. And if you could market that,
I agree. E-discovery is huge. I remember a couple years ago, maybe a few years ago, a paralegal said to me from another law firm, "We need the metadata." I didn't know what metadata was. I'm not sure how many years ago. It wasn't that long ago, embarrassingly enough. But it's huge now. You really gotta. If you have those skills. It's something that you could definitely market. There are companies out there that just do e-discovery. There's a few programs. One is Concordance. I'm not sure which one you use,
Right.
which are just mechanisms of the ability to both get discovery on a system and then let everyone look at it.
Right.
So there are companies. What I do in some of my cases, the bigger ones, is we actually employ third-party vendors to do all that, and they keep it protected, safe, confidential, because it is a huge business.
Right,
But
I mean, the vendors, the problem is that they don't know the law, which is constantly evolving. So you can't just rely on the vendors. So if you look at any law firm website now and type in e-discovery, law firms are developing a totally separate practice just devoted to this area. And it's attorneys, and I mean, there's a lot of benefits to it. You're developing a specialty. It's a better quality of life. You're still making a decent income in a large law firm. So I definitely would explore that if you have an interest in that area. It'll make you much more marketable.
And there's also a whole movement that's been around for years now, where you actually take computers and find, you could take a computer and find anything. I don't care how you try to delete it, unless you smash it against the wall. And there are investigators out there that literally will take hard drives, take laptops, and will find every email that was ever deleted, and even every draft of an email that wasn't ever sent. So there's a lot. It's a big business now, getting discovery you wouldn't otherwise have had. The whole email phenomenon has it's changed our lives, and it's changed litigation, because people say a lot of stupid things on emails. They just do. People just write emails. That never used to happen. It used to be the phone. And even text, there's ways to get text. Now, the different providers are AOL doesn't store, and I've actually subpoenaed AOL. I think Google, Gmail does have a longer storage period. So there are ways to try to get that. But if you're using a Gmail or an AOL account it's not yours. It's being stored. It's being hosted by someone else. So it may be harder to get. But that stuff it's crucial. Emails are crucial in any case. They really are. You're gonna hear two different answers for that one. Did you want to go?
No, go ahead.
I bring it up right up front. I don't care if I'm a plaintiff or a defendant. I don't bring it up. See, so long as you don't bring it up in a weak way, then I have nothing wrong with it. I will tell generally what will happen is my client gets served with a complaint on the defense side, and I'll talk to the other side, and I'll say, what's it about? I really don't know anything, even though I've been totally briefed by the client. I'll sort of play stupid, and I'll say, is there any chance we can settle this? What's your client really looking for? Let's just sort of open up that gate. I like opening in the beginning. And it may be a ridiculous amount in my client's estimation, but it may not be. And on the plaintiff side, sometimes it's a little harder because you don't know what the dollar amounts are. If you're talking about loss of future income or some kind of emotional distress damages or damages from an employment case where you have a therapist, you can't really quantify that. So many times you can't do it. But on the plaintiff side, I will talk to my client. I will say, listen, what do you really want here? And they always want the moon. I was fired, I want 12 years of salary. Well, you're not getting 12 years of salary. The best you're getting is maybe 3 years, okay? And if you get a new job, you have to mitigate. It's gonna reduce your amount. So I try to work on my client, reduce their expectations, and I will on the plaintiff side, maybe not come up with a number in the initial call, but certainly in the first 30 days, I will at least explore the possibility. I think it's a good idea. I'm not sure if you agree with that.
I mean, from the defense side, it's tough because you don't want to be seen as weak, right? I mean, but there always is a cost of litigation. So I try to bring up, if there's an opening to discuss settlement, like for instance, we're about to gear up in an arbitration right now. It's like an $8.5 million dispute, and we're going to spend about $1 million just gearing up for trial. So I said to opposing counsel, look, before we gear up, there's a cost of defense. Before we go forward with this, we think we have strong claims. What do you want to do? And he said, oh, we're open for settlement. Well, we want 7 figures, and that we're not even close. So I said, okay, let's just go forward. But I mean, there's always openings. If you just win a big motion, you could basically, you're in a position of strength, and maybe go to them and say, do you want to still go forward with this? And so I try to. It's strategic. It definitely is, because you don't want to be seen as too weak. And I also like to see the documents before, because sometimes you realize your case is not so good. So you have to find a way to get rid of it in a way you're not paying too much money.
That's a good point. There are also ways to have creative settlements, especially if you're dealing in the securities industry. Many times I will try to, through my broker-dealer client, maybe we can't give you $1 million of cash, but let's structure something where, obviously within the securities laws, where we can give you securities, or we can deliver securities, or we can change the date of an expiration of a warrant, or we can somehow remove a restriction on a security, which gives the plaintiff more value, and the defendant doesn't care about. So we try very hard to structure settlements using something other than money, which is maybe a big benefit to the plaintiff and not as much of a detriment to the defendant. Another way is taxes. I'm not a tax professional, but my understanding of the whether or not settlements are taxable, or any kind of award, it is, unless there's been some kind of physical injury. But there are ways if you have a discrimination case and the woman was both thrown down and discriminated against. Well, you can make the settlement for, let's say, $500,000, 60% for the damages and 40% for the discrimination. So that 60% is not taxed. So it means more money to the plaintiff than it would otherwise. So there are creative ways to try to settle things, and usually you got to really try very hard to do it. I always tell my clients, listen, tax consequences are yours and only yours, but I can do my best to try to, structure it so on the plaintiff side, taxes aren't yours, or on the defendant side, you get the deduction. Anything else? Go ahead. Yeah, I mean, the question is sort of explain the jury selection process. What I do is I try to, before I even go to trial, I say, who's my perfect juror? Do I want a woman? Do I want a man? Do I want someone from the inner cities? Do I want someone from the suburbs? Do I want someone who's really bright and well-educated? Do I want someone who's not so educated? And I've had all those answers in different cases. So I say to myself, what are my perfect jurors? And many a times you're literally shooting darts against the wall. That's sort of my first step. My second step is I look at the jurors. Look at what they're wearing. Look at are they reading the Post? Are they reading the Times? The Times to me means they're more liberal. The Post means they're more conservative. I could be wrong, but that's sort of my analysis. What book are they reading? Okay, what are they carrying with them? How do they present themselves? So I sort of try to put them in there's obviously people that do jury studies, but I try to figure out who I want and look at them and see who fits in that hole. And then you essentially ask questions. You ask, Every juror has to fill out a form which gives you all of their background, whether they've had other jury experiences, whether they have any convictions. You got to look at the form, and I generally ask general questions. Has anyone here ever had a case, blah, blah, blah? And if I get a raise of a hand, I will talk to them about it. And then I'll ask specific questions. Well, Mr. Smith, I saw you were in a securities arbitration against Morgan Stanley 3 years ago. How did it turn out? What happened? So I try my best to, at the end of the day, you want a juror that's going to be, I shouldn't say it on tape, you don't want a non-biased juror. You want a juror that's going to essentially agree with you. So you want to get someone who has had experiences, who you know, is going to side with you. For example, that guy at Morgan Stanley. Yeah, I sued Morgan Stanley. I hate broker-dealers. And if I'm a plaintiff, I'm great. If I'm a defendant, he's off. So you really, it's not easy. And a lot of times you guess and you guess wrong. But generally speaking, you have to figure out who you want in that box and how you get them there.
Right, right. No,
Repeat the question.
how do you protect
Correct.
privacy? Oh, the question was, how do you protect privacy when you're extracting electronic data from personal sources, right? Right. So, I mean, in every litigation, there's always a confidentiality agreement, right? So it's basically that you can't disclose any information outside the litigation. So that's the first level of protection that should be entered into in any litigation. And the second thing is that when we extract data, we're only going to produce documents or data that's relevant or potentially relevant to the litigation. So if you have emails on there from Facebook to your boyfriend, like, that's not going to be produced in the other side. Although sometimes they're produced and it's kind of fun. They're fun to review, but it's like, but anyway, that's the goal, is not to produce your personal data. But you all should be aware that, you know, anything's fair game now. So when you're in a case, if you basically could go on someone's Facebook account, you could subpoena data or ask for the parties to produce that, your Twitter, anytime you post something, you should always be aware and advise your clients. Like, you know, in an employment discrimination case, if there was a case like this where someone was claiming she was injured and she wasn't receiving disabilities, and then on her Facebook account she was water skiing. So you should always look at that, you know, because that is fair game in a litigation. So that's a good point.
Anything else? Well, thank you, guys. We hope you learned a little. If you have any questions, we're going to hang out for a little bit. But thank you.